Alrighty, this is Decent We the People News. One more time at it. Okay? This is educational purposes only. Okay? I'm not an attorney. I'm not giving legal advice. Anything I say or do is just my opinion. And it's just looking outside the box. Why? Because we never just look straight forward. We always look outside the box. Alright? Use the Second Amendment. Arm yourself with knowledge. Alright. Now, I'm led to believe there was probable cause in this and all that. Okay? Um, my nitpicking part about this is going to be towards the end of this. So be patient. I'll get back to you.
You are Stephen Chavez. Yes, sir. Mr. Chavez, you're charged of driving while intoxicated. Second offense. Or wait, Stephen? We've got two Chavezes, right? Okay, so you're charged of driving while intoxicated. Second offense. This is a Class A misdemeanor you're facing.
Oh, by the way, this is Vicky's Court Watch.
Up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. So you know you're not here alone. Your lawyer is here with you, but he's on Zoom. Yes, sir. Okay.
Yes, Judge. On March 6, 2025, the officer received a call from an officer who was finishing a separate, unrelated call and observed a vehicle stop 150 feet from the intersection for an unknown reason for a short period of time, then accelerate unnecessarily quickly before coming to a stop at the intersection. The vehicle was stopped straddling the dividing line between lanes and stopped past the designated stopping point. The vehicle remained stationary through several light cycles, and officers approached the vehicle. The officer observed the defendant, the driver and sole occupant, reclined in the driver's seat unconscious while the vehicle was running and in drive. The officers woke up the defendant, and the defendant appeared confused and took his foot off the brake, causing the vehicle to collide with the marked patrol vehicle placed in front of the vehicle. The officer observed the defendant to have red bloodshot eyes, slurred speech, and odor of an alcoholic beverage from his person. The defendant was transported to Pasadena jail for further investigation and denied drinking alcohol. Standard field sobriety tests were administered: HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to provide breath. The results were 0.183 and 0.180.
All right. He represents NCIC. How many DWIs does he have, and whether he has a license as well?
Yeah, the only DWI out of Minnesota, and his license is valid.
Okay. Mr. Chavez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. I'm now placing a restriction also on your license that you're not to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have an interlock, likewise you will go to jail. Listen, no.
Now, these are some of the issues I have. Okay? We talk about the 13th Amendment, this, that, here, and there. There's instruments involved in this and all that kind of stuff. All right? Which puts you into a slave. Now, the Constitution says that you have a right to be bonded. Okay? You get out of jail and you come back to court when the court days appear to fight this in court. Okay, now in this case here, I am led to believe and do believe that there's going to be a plea. Okay, which I think is crap, but I mean, you get less sentencing, so it is what it is today. The problem I have is most people don't think outside the box. Okay, I do like Judge Fletcher, them 100% of the judges I've seen. Okay, but it doesn't change the fact of we have all become so numb and so attached to creature of habits. And the reason why I'm saying this is the right to bond out. Okay? But it has no other extensions to it, constitutionally speaking. So when he says, well, you can't go drink, you cannot, if he's legal age to drink, but he can't drink? Well, there is nowhere in the Constitution that says just because you're on a bond that you can't do uh, your life outside of jail. You know, um, take that as you may, right? Obviously, do not drink and drive, people. Jesus, it's just ridiculous. Okay, you do put people at risk. I believe in victims, but at the same tokenations, you do put people at risk. Um, but they put all these other restrictions in there that's outside the square. Okay, the Constitution did not give that magistrate the authority to operate outside the square. He's to give a bond. The guy accepts a bond, and then he goes home and he waits for his court date. Right now, he may not be behind a cage, but he is, after he pays his bond and he's got all these restrictions, he is still a prisoner. Okay, sit and think about that. He has already been convicted. He is serving time. Okay? Without a true judgment. And we need to get our mindsets out of all this money-making schemes that they're doing, right? You're not allowed to drive the car without the breathalyzer test. You got to pay $300 for a machine to be put in your car. And then, for argument's sake, 6 months down the road, that you're found innocent, but you forked out all this money, so you was already sentenced before the sentencing. Okay, look at all the people in Tennessee, right, that went to jail. They had to give ID. They had to do paperwork while they was in jail, and there's that paperwork, right? Before he was even to be there for probable cause. He was already sentenced. He is guilty. Period. That's the reason why Texas law, I don't know about most states, and I'm led to believe it's all about the same. Criminal Code 14, 15, 16. All right? Go directly to the magistrate. Go directly to the magistrate. Go directly to the magistrate. Go directly to the damn magistrate. Before jail. It's not complicated. Breathe. All right? This is the issues we have in today's court. As this has been going on for so long, this judge is fairly young. So he was taught in law school, taught by other judges unlawfully to ignore the law. But he, in general, do not research the law. That's his job to do. Cannot comprehend all the other statute codes, rules, and regulations that go with 14, 15, and 16. Right? And the Constitution. Right? The Constitution plain out says he can't do this. And yet, we, and allege them not knowing this. And they're educated and don't know it. We got innocent people sitting in jail. Back it up a little bit more. Breathe. The issue at this point, more than anything else, is that there's all these other restrictions without being guilty. He is supposed to be presumed innocent. But he just now had a probable cause hearing. He's still under the authority right there of presuming this guy is innocent. But no, he is presuming he's guilty. You guys heard me 1,000 times. Excuse me. Once you make a plea, right? Not guilty, no contest, guilty. You made a claim and you put the burden on yourself. That's the reason why when you go into these courtrooms, you're presumed guilty. You made a claim. Okay? The only thing that anybody should do is walk in this courtroom, do the probable cause hearing. Shouldn't have had to sign not guilty, no contest, or anything. None of that is supposed to be allowed. Because when he walked in that courtroom, he is supposed to be presumed innocent. And then add in all these other things that's outside the square just because Mr. and Mrs. State of Texas decides, I'm going to write a statute that violates the Constitution. That way we're going to have to give all this extra enforcement and keep him locked up. Meanwhile, there's going to be a corporation out there making money because they paid us off to create this statute. So this breath machine, paid off some legislatures, and it says, oh, okay, well, if I give you, money to get you in office, could you do me a little favor and pass a law that, anybody's been drinking, they must have this machine? People, they don't care about you. It's all about the money. If they absolutely cared about you, they would go into family court and the family judge would tell you right off the top. Now, you do realize that in the jurisdiction of this court, of the subject matter jurisdiction, MRAM jurisdiction, or whatever jurisdiction, personal jurisdiction, you do realize that this is going to be contract law. Right, sir? Okay? We're going to be talking about, Anyway, we're going to be talking about family court issues of child support. Child support is a contract. Did you sign anything? Did you go ahead and sign the contract? Well, no, Your Honor. Okay. Right now, your case is dismissed with prejudice because the 4D program says that there must be a contract. This is We the People News. Bye, y'all.